Fox 10 recently asked me to be interviewed about a viral use of force incident involving a United States Fish and Wildlife Service officer. The officer deployed a taser near an active gas pump. Seconds later, the gasoline vapors ignited and the man being confronted was engulfed in flames. The television segment can only include a small portion of my analysis. I want to take a few minutes to explain the legal framework, the tactical considerations, and the training implications surrounding this incident. Before we begin, an important disclaimer must be stated. My analysis is based on the publicly available cell phone video and information reported by Fox 10. I have not reviewed the complete investigative file. I have not reviewed every body-worn camera recording, witness statement, radio transmission, officer report, or any item of physical evidence. This is not a conclusion. This is an educational analysis of the issues investigators will likely examine. So let's get started. According to Fox 10, the officer confronted Clarence Coyle at a gas station regarding an alleged trespassing incident that reportedly occurred approximately 20 minutes earlier at the Havasu National Wildlife Refuge. The U.S. Fish and Wildlife Service has said the officer's use of force is under legal review. So first, every law enforcement officer use of force is evaluated under the Fourth Amendment, an objective reasonableness standard established by the United States Supreme Court case Graham versus Connor. In my report, the primary considerations include 1, the severity of the suspected offense, 2, whether the person presented a threat to the officer or someone else, and 3, whether the person was actively resisting arrest or attempting to flee. The immediate threat factor is typically the most important. The analysis is not based simply on whether the person followed every command. Non-compliance and active aggression are not the same thing. A person may refuse instructions. A person may verbally challenge an officer, but those behaviors do not automatically create an immediate physical. Still has to be proportionate to the government need for using it. So this brings us to Bryan versus McPherson, a Ninth Circuit court case involving tasers, right? In that case, a motorist was stopped for a seatbelt violation. He was visibly agitated. He exited his vehicle, yelled and struck his eyes, but was unarmed approximately 20 to 25 feet from the officer and was not attempting to flee. The officer deployed a taser in a dart mode without warning. This was in 2010. The Ninth Circuit Court classified that the taser deployment as an immediate and significant level of force. This matters because significant force requires a correspondingly significant government interest. The court also explained that failure to comply with a command does not necessarily amount to active resistance sufficient to justify substantial force. The next important case is Matos versus Agarano. Matos involved 2 separate taser incidents that were considered together by the full Ninth Circuit Court, or we call en banc. The court determined that both plaintiffs alleged constitutional violations, because the governing law was not yet clearly established when those incidents occurred. Matos reinforced an important principle. The existence of some resistance does not automatically justify any level of force. Courts must still balance the nature of the resistance, the threat presented, and the severity of force being used. Another relevant case is Gravelet-Bondin versus Shelton. At the summary judgment stage, the Ninth Circuit considered evidence that the man was not the subject of original police response, was not threatening officers, and was not actively resisting when he was tased. The court held that a reasonable jury could find the deployment unconstitutional. This case emphasizes that significant force cannot be justified merely because someone is present, confused, slow to respond, or imperfectly compliant. Later proceedings involved a different evidentiary record, and a jury ultimately ruled for the officer. This illustrates why complete evidence matters and why conclusions should not be based on one isolated video alone. The last one we need to look at is we need to look at Barnes v. Felix, decided in 2025 by the U.S. Supreme Court. It was a deadly force case, not a taser case. Okay, but again, being a Fourth Amendment case, its reasoning is important to every use of force analysis. The Supreme Court rejected the Fifth Circuit's narrow moment of threat rule. A court cannot isolate only when the final second when the force was used and ignore everything that happened beforehand. The proper analysis considers what we call the totality of the circumstances. That includes a sequence of events leading to the usefulness of the officer's ultimate decisions. Applied here, investigators should not look at only the instant in which the taser was fired. They should examine the entire incident. Why did the officer approach the man? What legal supported the detention or arrest? What commands were given? Did the man understand why he was being detained and that he was being detained? Was he passively resisting? Was he actively pulling away? Was he attempting to flee? Did he make any perceived movement that could be perceived as an attack? Did he reach towards his waistband or another potential weapon location? What did the officer know before the moment of the attack? Were there additional officers available? Could the officer have created distance or waited for assistance? All of those facts matter, but are not all inclusive. But this contains another major issue that goes beyond the ordinary constitutional force analysis: the environment. The confrontation occurred in an active gas pump. Gasoline itself does not need to be visibly pouring across the ground to create danger. Gasoline vapors are highly flammable. A taser cartridge uses a small electrical component, air to launch electrical probes, and created by a device that may serve as an ignition source under certain conditions. The ignition source is the electrical impulse. The Department of Interior maintains specific department policy regarding those use of the electronic devices. Fox 10 reported the Department of Interior policy warns against electronic control devices near flammable or explosive materials. That makes the location of this deployment central to the analysis and not incidental. There are therefore at least two separate questions. First, was the use of force an immediate level of force constitutionally justified? And second, if some force was justified, was deploying this particular system in this particular environment tactically reasonable? Those questions are related, but not identical. An officer may possess lawful authority to use force and still select an appropriate. As violating an agency policy does not automatically prove the constitutional violation. Constitutional law, agency policy, manufacturer warnings are all separate reasonable categories. Training standpoint, this incident demonstrates why officers cannot simply be taught how to operate a taser. They must be taught when it to be used, where to use it, when not to use it, what environmental hazards must be considered, and what alternate tactics may be available. Remember, equipment proficiency is not the same thing as decision-making proficiency. They're two separate things. An officer can operate a weapon exactly as designed and still deploy it. Modern training must include scenario-based decision-making, and officers must be exposed to fuel pumps, aerosol sprays, oxygen-rich environments, bodies of water, moving traffic, and other circumstances where an otherwise lawful force may create an additional hazard. We all discussed the difference between outcome and reasonableness. The fact that someone suffered catastrophic burns does not in itself prove that the officer's decision was unconstitutional. Courts do not determine reasonableness by solely looking backward at the injury. That's hindsight. But the injury may reveal that a known or foreseeable hazard existed. The proper question is whether a reasonable officer facing similar circumstances, possessing the same information, should have recognized and otherwise accounted for that risk. Publicly available video, I have serious questions about the governmental need for this level of force. I also have serious questions about the decision to deploy an electronic control device directly beside an active fuel pump. Those are questions. A final conclusion requires the complete evidentiary report. My role is not to automatically defend the officer. I'm also not automatically to condemn the officer. My role is to legal standards, to compare the conduct to accepted training and policy, and to objectively evaluate whether the evidence demonstrates. Every critical incident should become a training opportunity, regardless of hindsight. Not because officers operate in a perfect world. They do not. They make decisions under stress with incomplete information and often within seconds. But that reality makes comprehensive training more important, not less important. We should be teaching officers more than how to deploy force. We should be teaching them how to recognize when the environment transforms and an otherwise an available tool isn't into an unacceptable risk. The public deserves objective accountability. Officers deserve realistic, legally defensible training, and both deserve an investigation that examines the entire encounter rather than focusing on the moment. Slogan: I'm a retired officer, an expert witness in the realms of use of force, firearms, and police training, and a Force Science Certified Analyst. Please watch Fox 10 for the complete investigation. Then subscribe to this channel for additional analysis of police use of force, law enforcement training, human performance, and decision making. Thank you.